I call to order the regular meeting of the Lakewood City Council of November 25th, 2013. Will the clerk please call the roll?
Murphy?
Here.
Kellen?
Here.
Wickman? Here. Quinn?
Here.
King? Wilson? Here. Fairway? Johnson?
Here.
Paul? Here. Coop?
Here.
Roybal?
Here.
You have a quorum.
Thank you, and as always, I would like to welcome everyone, and thank you for coming out tonight to participate in your local government, and particularly on this very, very special evening, this really celebration of democracy that we get to take part in every 2 years. Before we get started, I would ask everyone to rise for the Pledge of Allegiance and remain standing for a moment of silent prayer. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Please be seated. Well, as I say, this is indeed a very special evening. You know, it's an occasion that's it's bittersweet in the sense that we have to say goodbye to great public servants and great community leaders in Diana Wilson and Sue King, and we've had ample opportunity to do so privately and publicly, and we will one final time thank them for their service. At the same time, we get to welcome welcome 2 new leaders and 5 members that were elected to Lakewood City Council. 3 of them continuing their public service, and as I say, 2 new. It's a solemn occasion because this is they're about to take an oath tonight, a sworn duty. They're swearing to uphold their duty under the laws of the country, the state, and the charter of the city of Lakewood. But ultimately, it's a joyous evening, and there are lots of friends and family here to share in that joy. And by the way, as we get started, we're not just welcoming the city council members, but we're also re-welcoming 2 judges, our presiding judge, Ann Stavig, and our municipal judge, Daniel Ramsey, who are also re-elected. So there's going to be a little bit of ceremony here. I'm going to go down first and swear in Judge Stavig as our presiding judge, and then she will take over and do her official duties to do the rest of the inductions, and then we'll take some pictures, and at the conclusion of all that, we're going to have a recess out in the atrium. There's lots of people here. There are lots of cupcakes, and again, this will be a time of joy and of celebration. A lot of folks worked very, very hard, and I know that everyone's looking forward to their coming term of public service. So before I go down there again, Diana, Sue, thank you so much for everything you did. They're like, get on with it, would you? Okay, Judge Stavig.
Thank you, Mayor Murphy.
All right. Please raise your right hand. I. State your name.
Yes, I, Ann Stavig.
Do solemnly swear or affirm.
Do solemnly swear or affirm.
That I will support the Constitution of the United States of America.
That I will support the Constitution of the United States of America.
The Constitution of the State of Colorado.
The Constitution of the State of Colorado.
The Charter, laws, and ordinances of the City of Lakewood.
The Charter, laws, and ordinances of the City of Lakewood.
And that I will faithfully perform the duties of presiding municipal judge for the City of Lakewood, Colorado.
And I will faithfully perform the duties of presiding municipal judge for the City of Lakewood, Colorado.
Congratulations.
Thank you, Mayor.
got one for.
Hear those? Thank you.
Take over.
All right, thank you. And if I could have Judge Daniel Ramsey come forward. And I'll have you raise your right hand. I, Daniel E. Ramsey,
I, Daniel E. Ramsey,
do solemnly swear or affirm
do solemnly swear or affirm
that I will support the Constitution of the United States of America,
that I will support the Constitution of the United States of America,
the Constitution of the State of Colorado,
the Constitution of the State of Colorado,
the Charter, laws, and ordinances
the Charter, laws, and ordinances
of the City of Lakewood,
of the City of Lakewood,
and that I will faithfully perform the duties of
and I will faithfully perform the duties of
Associate Municipal Judge for the City of Lakewood, Colorado.
Municipal Judge for the City of Lakewood, Colorado.
Congratulations.
Thank you.
If I can get you to come sign.
Thank you.
Right. If I could have Ramey Johnson. All right, step right up and raise your right hand. I, Ramey Johnson,
I, Ramey Johnson,
do solemnly swear or affirm
do solemnly swear or affirm
that I will support the Constitution
that I will support the Constitution
of the United States of America,
of the United States of America,
the Constitution of the State of Colorado,
the Constitution of the State of Colorado,
the Charter, laws, and ordinances
the Charter, laws, and ordinances
of the City of Lakewood,
of the City of Lakewood,
and that I will faithfully perform
and that I will faithfully perform
the duties of City Council member
the duties of City Council member
for the City of Lakewood, Colorado.
for the City of Lakewood, Colorado.
Congratulations. All right, and Scott Coop. Right. You'd step forward and raise your right hand. I, Scott Coop,
I, Scott Coop,
do solemnly swear or affirm
do solemnly swear or affirm
that I will support the Constitution
that I will support the Constitution
of the United States of America,
of the United States of America,
the Constitution of the State of Colorado,
the Constitution of the State of Colorado,
the Charter, laws, and ordinances
the Charter, laws, and ordinances
of the City of Lakewood,
of the City of Lakewood,
and that I will faithfully perform
and I will faithfully perform
the duties of City Council member
the duties of City Council member
for the City of Lakewood, Colorado.
for the City of Lakewood, Colorado.
Congratulations.
Thank you, Judge.
Thank you. Congratulations. All right. And I have Shakti. Yes. All right. Step right up. And I'll have you raise your right hand. And I, Shakti,
I, Shakti,
do solemnly swear or affirm
do solemnly swear or affirm
that I will support the Constitution
that I will support the Constitution
of the United States of America,
of the United States of America,
the Constitution of the State of Colorado,
the Constitution of the State of Colorado,
the Charter, laws, and ordinances
the Charter, laws, and ordinances
of the City of Lakewood,
of the City of Lakewood,
and that I will faithfully perform
and that I will faithfully perform
the duties of City Council Member
the duties of City Council Member
for the City of Lakewood, Colorado.
for the City of Lakewood, Colorado.
Congratulations. All right, and David Wickman. Right, and I'll have you raise your right hand. I, David Wickman,
I, David Wickman,
do solemnly swear or affirm
do solemnly swear or affirm
that I will support the Constitution
I will support and defend the Constitution of the United States
of the United States of America,
of America,
okay, the Constitution of the State of Colorado,
the Constitution of the State of Colorado,
the Charter, laws, and ordinances
the Charter, laws, and ordinances
of the City of Lakewood,
of the City of Lakewood.
and that I will faithfully perform
I will faithfully perform
the duties of City Council Member
the duties of City Council Member
for the City of Lakewood, Colorado.
for the City of Lakewood, Colorado.
All right, congratulations.
Thank you.
Right, and Karen Harrison. Step and raise your right hand. I, Karen Harrison,
I, Karen Harrison,
do solemnly swear or affirm
do solemnly swear or affirm
that I will support the Constitution
that I will support the Constitution
of the United States of America,
of the United States of America,
the Constitution of the State of Colorado,
the Constitution of the State of Colorado,
the Charter, laws, and ordinances
the Charter, laws, and ordinances
of the City of Lakewood,
of the City of Lakewood,
and that I will faithfully perform
and that I will faithfully perform
the duties of City Council Member
the duties of City Council Member
for the City of Lakewood, Colorado.
for the City of Lakewood, Colorado.
Congratulations.
Thank you.
Oh, I need somewhere to sign.
Sure, but now it's time to sign your life away.
Yeah. I knew there was a catch to this.
Thank you.
Give the press corps a chance.
Yes.
All right. That went pretty smoothly. Thank you, Judge.
Thank you.
I again congratulate all 7 of you who were just sworn in, and once again thank Diana and Sue. And I now declare a recess at 7:15. We're going to go out in the atrium and celebrate a little bit, friends and family. And we will reconvene at 7:40 in 25 minutes. So enjoy. And thank you all again for being here.
Meet you the night of state court. So running after that was running out the door that night. Congratulations. Thank you, and I enjoyed the conversations with your son. It seems like it's good stuff. We're both going to be over. And
All right, I call back into session the regular meeting of the Lakewood City Council of November 25th, 2013. That was a very special little celebration out in the atrium, and again, congratulations to the winners who are up here now, and look forward to working with you for the next 2 years for me and 4 years for you all. We have to do something a little bit different. We have a new city council here, so we took roll call a little bit earlier this evening. We have to do it again. So will the clerk please call the roll?
Murphy,
Here.
Ellen,
Here.
Wickman, Quinn,
Here.
Shakti, Harrison, here, Barraway, Johnson,
Here.
Paul, Coop,
Here.
Royball.
Here.
You have a quorum.
All right. The first item on the agenda is a proclamation, and as I think many people are aware, this Saturday is Small Business Saturday, and it's something that is being promoted nationally. The Women Impacting Public Policy Small Business Saturday Coalition asked me as the mayor, and asked a lot of mayors around Colorado and around the country if they would call attention to small businesses and to shop this Saturday by reading the proclamation. So to read it, I'm going to ask Adam Paul, and Adam, as many of you know, serves as our representative on the Jefferson Economic Development Corporation. So I'd like to ask Adam to read it into the record.
Thank you, Mayor. Before I start, just two quick facts about businesses in Lakewood. 80% of Lakewood-based businesses have fewer than 20 employees, and home-based businesses comprises about 25% of our active sales tax. So small business is very important to the community. Proclamation, Small Business Saturday, November 30th, 2013. Whereas there are currently 28 million small businesses in the United States that represent more than 99% of American companies, create 2/3 of new jobs, generate half of private gross domestic product, and employ 1/2 of those working in the private sector. And whereas consumers across the country agree that small businesses contribute positively to the local community by supplying jobs and generating tax revenue. And whereas consumers also have small businesses in their communities that they would miss if the small businesses closed. And whereas U.S. consumers believe it is important for people to support the small businesses that they value in their communities. And whereas consumers are encouraged to pledge support for a buy local movement. And whereas advocacy groups and public and private organizations across the country have endorsed the Saturday after Thanksgiving as Small Business Saturday. Now, therefore, on behalf of the City Council and the people of Lakewood, I, Bob Murphy, Mayor of the City of Lakewood, Colorado, by virtue of the authority vested in me, do hereby proclaim November 30th, 2013 as Small Business Saturday.
Thank you, Councilor Paul, and I just encourage everyone. I know that Friday's Black Friday, kind of traditionally the big box day, but Saturday is a Small Business Day, and we have them throughout Lakewood, whether it's on Colfax Avenue, at Jewel and Wadsworth, Belmar, of course, up and down our city, and throughout the city there are small businesses. So think of them. Think of our brick and mortar businesses when you're out there shopping. So thank you in advance for your support. Will the clerk please read item 7 into the record?
Item 7, Resolution 2013-58, appointing and reappointing members to the Lakewood Advisory Commission for an Inclusive Community.
All right, we have several new appointments and reappointments tonight, and I thank everyone in advance for their willingness to serve, and I would ask Councilor Coop to read the motion.
Mayor Murphy, I move for the adoption of Resolution 2013-58.
Second. Will those folks that have volunteered to serve on our advisory commission for an inclusive community that are here tonight, please stand? Wow, everybody's here. Thank you very, very much. Thank you for being here tonight. Thank you for your willingness to serve. You know, we ask a lot of the ACIC, as we call it, the Advisory Commission for an Inclusive Community. We've expanded the role a little bit recently this year with sort of an ambassador program where we're asking folks to attend regular meetings of other organizations in the county so that they can keep us abreast of what's going on. So that's just one of many, many duties that many important roles that you undertake. And as I look down the way here, Shakti, you were on the advisory commission. Karen was on the advisory commission for inclusive community. So if you're not careful, you could wind up here. Thank you very much for your willingness to serve. We appreciate it very much. We're going to vote. All right. So we... Right, we will. Okay, so I would ask, did you want to speak? Okay, Shakti? Go ahead.
I just came off ACIC on Friday, and I served for 3 years, and I think it's an amazing opportunity for citizens and for the city to have the input of all of these talented people. And so I'm putting in my 2 cents for all of you and for the process.
Great. Thank you. All right, we have a motion and a second. Please cast your votes. And it passes unanimously. Congratulations and thanks once again. Look forward to working with you. All right, on to public comment. This is the point in the meeting where the public is invited to address the City Council on items that do not appear on the agenda. We ask that all comments be directed to City Council. We ask that everyone here tonight observe the decorum of council chambers and refrain from applause or audible support or discord with the speaker. There is for those of you that haven't been here before, we'll ask you to come down to the podium. And there's a time limit, of course, of 3 minutes, and you'll see some lights down here. When it's green, it's green for your first 2.5 minutes. When it reaches yellow, you know that you have 30 seconds left. And then when it reaches red, we'd ask you to wrap up your comments. And then I'll start by reading off the list of those who indicated desire to speak by signing up, and then offer that opportunity to anyone else in chambers who maybe didn't get an opportunity to sign the list. So I will start out with Wayne Dieterhouse, 1595 South Marshall. Did you wish to? Is it Niederhouse? Sorry. The end kind of came together there. My fault.
I, along with a large number of the folks here today, have a concern about a group home, or now a series of group homes that are being integrated into our residential areas. I have 2 properties that are within 5 blocks of one of these groups homes that are being constructed right now on Newland Street. And while I believe that there are probably some revenue opportunities for the city coming from this, I believe it's extremely short-sighted in that the property values on every home in that area are significantly going to be damaged, which is going to damage the tax base and it in fact cost the city more than it's going to gain from this short-sighted revenue opportunity. There are third-generation families now in this neighborhood, and not a single one of them was aware of this happening until ground was broken, foundations were poured, and then word started passing through the neighborhood. So if this was published in any forum, it was done in some kind of forum that was not, in my opinion, legitimate. And I'll leave it at that.
Thank you. Kathy Niederhouse, did you want to speak? Okay. Elaine Karcher? All right. Lou Jones, Mike Young,
Hi, concerning the properties that he just spoke of, 1570 South Newland was the lot that my father owned, and I sold to the person that's building the unit there. At the time it was R1. I had no idea this was going to happen. My parents built on the adjacent lot. We moved in 1956. I grew up there. Florida was a dirt road. It was just tire tracks down to our lots. It was a great place to grow up, and I still have friends and neighbors that live there that are seriously affected by this. I know that time marches on, and I know that we can't hold on to the past. My problem here is the way it was done. As I understand the rules for rezoning, there should be notification so that people can at least express themselves before this happens. I don't see that any of that happened. And it bothers me, it disturbs me, and it really embarrasses me. I'm ashamed of the city of Lakewood, where I've been a resident since 1956, why they treat people this way. I'm very unhappy. Thank you.
Okay. Thank you, Mr. Young. Russell Pompey.
Mr. Murphy, members of the council, thank you for your time. Before I begin, I would like to say that I second the motion of the two gentlemen who spoke before me, but my topic is unrelated. Tonight I have for you a short text and an argument. I'll begin with the text. The following are excerpts from a website called sitehealth.com, a ratings website for healthcare providers. The following reviews are for a physical and mental healthcare corporation here in Lakewood. One reviewer wrote, "This place is disgusting. It always smells like urine and smoke. From the outside in, you'd guess it's a crack house." Another wrote, "They won't make change on any amount or accept coins, which are legal tender. This forces patients to go to the nearest business to break bills, which is a liquor store. To the staff, I say, total lack of professionalism." Another reviewer, I quote, "They killed my dad there. God knows what else they've done." Medication is given out wrong, and nothing is done about it. Nobody should be allowed to treat people the way the staff do at that place. Another woman wrote, "My husband is sick, and they will not allow me to drop off his medication. Do not send any family member to this facility, or else be prepared for them to have their human rights trampled upon." And finally, a reviewer wrote, "Recently, they had a 35-year-old woman hang herself in her room." Those are the texts. Here is the argument. Alexander Hamilton once famously said, "The first duty of society is justice." The aforementioned healthcare facility is not 2 miles from here as a crow flies. It is called Intervention Community Correction Services, a private probation company and mental health facility on whom Jefferson County contracts off its essential correctional and mental health services. Its recorded success rate is 11%. I argue that when a government cannot fulfill its moral obligation to rehabilitate its troubled and resorts to outsourcing justice to private corporations, that government has failed us. I yield back the remainder of my time.
Thank you, Mr. Pompey. Corinne Bryant. Welcome.
Talked to you last month.
Yes, you did.
I didn't say much. I don't have much to say this time. I feel like there's been some changes made that aren't right. And the fact that they're building a house now in our neighborhood that's twice the size of our houses. How is that? How can they do that? I can see where they can take a house and make it into another group home. But how can they go and build a house that's twice the size in my neighborhood, in my block? I live right across the street of one house north. It's very ugly. That's all I have to say.
Thank you. Steve? Yeah.
Mr. Mayor and City Council, and Tom Quinn, please pay attention. Thank you. In the movie Cool Hand Luke, the warden has a famous quote. He says, "We have a failure to communicate." Why I bring up this quote is I feel that you guys have exactly done the failure to communicate with your constituents in the county, the people who pay the taxes, the people who are living in these houses where the group homes are going in. You didn't. You failed to communicate that the property was being built as a group home. You failed to notify the residents within 300 feet of this oversized house, non-standard house. You failed to communicate exactly what a group home is and who can go in there, how it can be operated. I spoke to Doug Jones, who is apparently a Lakewood City Council or city building planner, and he told me this is as follows. He said the building will be assisted living care building, and that memory care is different from dementia, and therefore patients or residents with dementia will not be allowed. But then he told me there's a problem. There's no delineation that you guys, the City Council or City of Lakewood, have for delineating between memory care and dementia. So how are you going to enforce this? You have a rule, you have a statement of what this is, but you can't enforce it if you don't have a definition. He said the building will not be locked. He said the residents are free to come and go. Well, if these patients have dementia, or if they have memory care problems and don't know where they belong, and wander into neighborhood houses because they think they belong there, that can be a problem for the residents. He told me that there will only be two staff members at any one time. He said their primary care is to give them food, not primary care, not to provide residents with any primary care. So we really don't know whether Doug was speaking. I mean, he wasn't speaking in official capacity, but we really don't know whether he was speaking the full and true and complete specifications of what has been laid down for these memory care locations, this group home. So we have been left to gather, well, basically we've been given inconsistent and misleading information about what's going on and what's going into these homes. I spoke to the superintendent who's building the 1570 South Newland property. He said the owner plans to sell it shortly after it's finished. Who knows what the next owner will come in and ask for you guys to do? Will he ask you to change the ordinance so that now it can be a troubled teen home? Will he change it to dementia home? What will he ask for? You didn't tell us what was going in there before. How can we trust that you will tell us before it happens when it gets changed? You have failed to tell us that it's coming. Stop your failure to communicate. Give us full disclosure of what is currently permitted at the group home. We want specific, enforceable laws that the owner must follow. We want to know these.
Thank you, Mr. Bryant. We're going to, you passed it a while ago, but we are going to address that communication issue this evening.
Thank you.
All right. Tom Dorsey? Okay. Don Young?
Good evening.
Welcome.
What I want to start with here is...
We have some things that we can show.
Okay.
Do we have a...
Document camera?
Mayor Murphy, if I may, I take notes. So that's what I'm doing up here. I'm not responding to emails. So please don't make comments about that. That's part of what I do is make notes of what people are saying. Thank you. Generally, if you see me typing, I'm taking notes on what's being discussed.
Thank you.
Well, there was a comment last time, and somebody clearly took offense that I was doing that. Thank you.
You want to lay this up here?
Okay.
Well, what we're asking here is, obviously, we've had a conversation with City Planning Director Travis Parker. And what we have here is his response to some of our comments and questions. And, as you note, the date is November 8th. And a couple of the issues that we want to bring specifics to is...
Can we focus that any better?
Okay. Anyhow, the questions that are asked about Ward 3, which is was specifically detailed in here, that group home applications for Ward 3, and it's the highest concentration of residents over 65 years old, which is 15.8% of the residents are over 65. So it's the highest number within the various areas within the city. So what we're asking is, these are the most vulnerable individuals, obviously, citizens that are hoping that they won't... City, I'm sorry. Help me with that there.
Yep, the city's hoping. Go ahead, this is your time.
Okay. The city's hoping that citizens won't make any comments or rally to stop any of these issues. Okay. And finally, the status of the developer and the company. It's a lawsuit, and we've got documentation here in reference to the individuals that have applied for the applications for these various areas. And what we'd like to know is, can you tell us what is a reasonable time frame for this investigation and to take place, and acknowledge that the contractor's status has changed and the contractor is delinquent. And then finally, the city has committed that they want to express the city's commitment to the protection of the residents, and that whatever legal and defensible actions that the city can take. So what we'd like to know is, why has the permit not been canceled? If the city is fully aware of these issues, and what protections do the neighbors have, for the neighborhoods, and what would they not be allowed size of this corporate building in these residential neighborhoods? Okay. Do you want to start this?
Did you start the clock, Margie? I don't know if you did. You didn't? Oh, you did. Okay. Well, there are two of you, so if you want to take... I know. Please continue.
Yes, I'll move the papers. Thank you.
Okay, so real quick, because I know we're really, you only give us 3 minutes. But here, 9000 West Virginia, this is a building permit from the city of Lakewood. And on the application, you can notice that the name Dwayne Cerniglia, and there's several different parts to this. Also, we've got Williams Lyons, Dwayne Cerniglia. We've got a couple of the companies, Ralston Ridge, Springfield Construction, et cetera, et cetera. We've got all kinds of this in here. Ranch Communities Corporation. They have put all this stuff into their application. What I want to show real quick, because I know we're running out of time, is that these companies are Ralston Ridge. This is off of this Colorado State website, is delinquent. Another one that he has, Springfield Construction, is delinquent. Another one, and this was delinquent in 2011. The other one was 2012. He applied for this in 2013. This one is delinquent in 2009. This company's delinquent in 2011. This company is delinquent in 2004. And these are all companies that he put on his application for his permit, and his permit was granted. So I don't know what the city is apparently not reviewing these applications. Here's the next one. This is the application and the builder permit that was granted for 1570. Same thing. They have the Dwayne Cerniglia Williams Lyons. They also have the address of 9110 West Virginia, 9110 West Virginia. That's delinquent as of 2012. He also has in there here Dwayne Cerniglia and Canyon Willow Builders, permanently revoked. And when was that? 05? 1998? So that one also. The next one, and I'm sorry this seems a little scattered, but I only have 3 minutes. So the next one, there are 2 lawsuits. We have the names Williams Lyons, who is the property owner for all of these, for the 9000 Virginia and also for the 1570 South Newland. And another one. This one is from Douglas County, and this one is for Arapahoe County. And these are lawsuits that are already currently in place and going through, and the reason that they're going through is because of poor construction. And here's 2 more companies that they listed that are on the list of the lawsuits here. Creekside Homes, Triton Development. Creekside Homes, it was delinquent is in 2009. And here, so far we're in good standing because we haven't really started with this one. So I'm kind of anxious to see how this one's going to turn out too.
All right, thank you. And let the record show those are that's the Secretary of State's website that you're required to put in your annual report every year. I have a couple businesses that's just a reporting requirement is what that is from the Secretary of State, basically saying you're still in business. So thank you.
Hi.
Hi, welcome.
I live just south of the house on 1570 South Newland. And all of the property that they are building, if anything happens to any water, any sewage, it's going to come right into my house because they have no property around the building for the people to get out. Why do they have to make it as big as it is? I mean, if it was just 2 or 3 or 4 people, I don't think we'd be yelling and getting upset over this, because at least the people would be treated like human beings and have a place to go outside and feel like they lived in the area. This way they're going to be stuck inside. They won't even see the sunshine unless they're lucky enough to see it through the doors or the windows. I'm really disgusted. I really thought Lakewood was a pretty neat place. We've lived there since 1960. My kids that are here all were born there. What have you done to us? I've got other neighbors here that are older than I am, but they're still members of the neighborhood and have been for many years. Don't you care about the people that were there? Do you have to allow someone to bring all this into our area without us having any knowledge of it? And we didn't. We looked at a paper just last night or the night before that said it was still R1 in November of 2012. So it was all changed without us knowing. And we really don't appreciate it. We thought Lakewood was a pretty neat place to be. But now you don't care about us. Can you answer that?
We do care. Thank you.
Wish you did.
Thank you.
Thank you.
Could I have your name, ma'am?
Sandy Young.
Thank you.
I did sign. It's on the back.
Okay. Thank you. Just want to make sure everybody gets a chance. Let me just kind of benchmark a couple things here. I want to turn to Mr. Cox on a couple of issues. Number one, this neighborhood and this lot is still zoned R1, correct?
Correct.
All right. The zoning has not changed. Number two, there was some. I know Ms. Springsteen and the the Youngs just put put forth some papers that talked about some failure to report businesses and some lawsuits and that sort of thing. And I know the attorney's staff has looked into it. Could you comment on the results of that?
We looked at the company that was the applicant for the permit. I think it was the West Virginia entity. And as the mayor said, there are reporting requirements, and a failure to meet those reporting requirements for the Secretary of State results in a company being identified as delinquent or not in good standing. In our experience, that's what it usually is triggered by, and we're still looking at, obviously the list of companies was quite long. It's not unusual for a developer to have a different company for every project, and so there are a lot of them involved, but they may or may not be part of this application process. But the only place that we're aware of that the status on the Secretary of State might be an issue for the city is with regard to the registration of the businesses. We have a contractor registration process. It's not connected to the building permit process per se. If you want to do business in the city of Lakewood as a contractor, you register as a contractor, and there is a requirement that you comply with all applicable laws. And so we're looking at that possibility to see if the registration requirements have been met for these various entities. That's what we're doing on that front.
Okay. Any other? Let me. Sorry, guys. Let me switch here to my screen. Councillor Paul and Councillor Quinn.
Thank you, Mr. Cox. Had this process been started prior to April 1, I think, when everything went into effect as the new zoning ordinance came into effect, could this type of project been built prior to with our old ordinance?
I'd have to compare side by side, but my recollection is that the standards for building a group home in a residential neighborhood have not changed from the old zoning ordinance to the new. Notice requirements changed, and that was it. But the ability to build on that lot for this type of use would have been the same, I believe.
Okay, thank you.
Councillor Quinn.
Thank you. Mr. Cox, there are a couple of the comments pertain to the actual operations of these facilities. Do you know what legal entity is responsible for regulation of group homes in Colorado?
The state.
Is there what specific agency is responsible for that?
It's I'm drawing a blank here.
I'm sorry, I didn't mean to put you on the spot on that one, but it is the state of Colorado.
It is the state that licenses the homes and conducts inspections of the manner in which they're operated, the safety of the residents, access. All of those operational functions would be regulated by the state licensing process.
Okay, and that's not something that the state has legal responsibility for. I'm sorry, that the city has legal responsibility for.
That's right. We have very limited control over the process.
Okay. Thank you.
Well, I guess I opened it up here, but that's okay. Karen, we'll get back to public comment. Just want to clarify some things here.
I'll hold off till later.
Okay. Councillor Roybal?
Oh, thank you, Mayor. Mr. Cox, I have another question for you. In reference to certifying or getting your business registered as being a certified contractor, at the bottom of your application, what's the meaning on it? And let's say, for example, if you fill out all the current information, you submit your information forward, but at the very bottom, you swear that everything is current or is in good standing, and then you certify it by signing it. Was this process done with this particular contractor?
As far as I know, it was. I know that the contractors that we've looked at were registered with the city, and I don't have the form in front of me. I haven't committed it to memory, but I assume there is a statement that the foregoing information is complete and accurate, and so on. So,
now, my next question would be: is if the contractor seems not to give correct information forward, what would be the result of the city? How does the city verify it? How would they? What would be the process if, in fact, they didn't give accurate information?
I'd have to check with the chief building official to be sure, but my understanding is that the city staff does not verify the information on every application. If the contractor states that the information is true and that he's registered, that would be accepted. And then when there are circumstances that arise, as you said, after the fact, that might lead to some concern that the information was not accurate, then the city would look at it as we're doing with some of these entities now. But it would not be routine for the city to verify every fact that's stated on the application. That's the purpose of that statement.
Correct. Now, that being said, if the city discovered that it wasn't accurate information, what would be the process for the city to move forward, possibly suspending the contractor's license and or the permit until that was satisfied?
There is a process in our municipal code for suspending the registration if it's found that, for example, there's a long list of things that a contractor must do, but one of them is a sort of a catch-all, any conduct that's unlawful or what have you. But there are several possibilities. Any conduct constituting fraud or misrepresentation can be grounds for suspension of the registration. And I think it's important to note that we did have at one time a licensing process. Today it's a registration process, which may sound exactly the same, but really it's a sort of a administrative keeping track of names and addresses, contact information. There's not an evaluation process of the contractors to determine if they comply with licensing requirements. It's you register, and this is the mechanism we have for following up if there's a reason to believe the information was not accurate.
Okay. If we discover that the information wasn't accurate, can we ask again, would it be possible to suspend the permit or the contractor's license till this is investigated, and either grant him back his permit and his contractor's license, or completely suspend it indefinitely?
That's what we're looking at now. The code does provide for suspension of registration. I'm not aware of it providing a similar suspension or rescission of the permit, but those are the possible remedies that we're looking at now.
So now that you're looking at it, what is your timeline on this particular investigation?
A matter of days, I'd say.
Okay, thank you.
Last question, Ramey?
Thank you, Mr. Mayor. I have a question and a comment. Several people mentioned the size of the facility. Do we have anything in place that speaks to a residential neighborhood where we've got an extremely large building that's coming in that does not fit within the character of that neighborhood, or how does that work?
In a residential zone like the R1, there are standards, as you know, for the size of the lot, setback requirements, front, rear, and sides, height limitations. Those are the parameters under which a structure can be built within the residential zone. And if a building fits within all of those standards, meets the setbacks, meets the height requirement, then it can be built, whether it's a single-family home or, in this case, a group home. So it has to comply with the zoning as a single-family home would.
Tim, would this have been the same case with our old zoning?
The standards were the same in terms of setbacks. That did not change. I should qualify that. We made changes to the various zone districts, redesignated some of the names, and I can't sit here as I tell you tonight that the setbacks and height requirements are exactly the same in R1. I believe they are, but nothing was changed with regard to what could be built for a group home. Whatever could be built on that lot as a single-family home, the same parameters would apply for this type of facility.
Okay. And I have a comment. I am extremely concerned about the comments that the young man made regarding the intervention community corrections health facility. Is that correct? I don't believe that the city licenses these facilities. At one point in my career, I was a surveyor with the Colorado Department of Public Health and Environment, and it's listed in the phone book. It would probably be a good place to start making some inquiry through them to find out who licenses this facility and put in a grievance and see, if their license can stay in place with this kind of activity going on.
I want to be cautious about, we've heard testimony from one person, that facility's been there for 30 years. It's operated by it's a county, it's a Jefferson County facility.
And actually, could I point out, it's
Yeah.
not a health facility, it's
Not
a
a health
prison.
facility. It's a
jail. It's community corrections.
It's a community corrections facility. So, okay, let's go on with. So we're going to go on with public comment. I want to just sum up a couple of things. There's a lot of concern about the April 1st, the new zoning ordinance that went into place in April 1st. Nothing changed about the ability to build a group home in the city of Lakewood as a result of that zoning ordinance. What did change was the notification. And what we've heard from you tonight, and we'll continue to hear, is that the notification was not there. That was the change that was made. And as I alluded to earlier, we're going to be talking about that. The Planning Commission, just this past Wednesday, in their process of kind of tweaking their 6-month review of this new zoning ordinance, recommended a change to the notification that would involve a letter to everybody. And we're going to be reviewing that on City Council. They made that recommendation to Council, and we perhaps might even be thinking about taking that a step further. So more on that later. But the zoning didn't change. The ability to build a group home didn't change as a result of the new zoning ordinance. The notification changed for what would seem like a good reason at the time, but we're going to be taking another look at that. So let's continue. Rachel Hansgen. Sure, just...
Good evening, Mayor, City Council.
Good evening.
I'm going to talk a little bit about what Lakewood, I believe, is doing very right. I am Rachel Hansgen. I work with a nonprofit organization called Groundwork Denver. We are an urban environmental organization that works in Denver and the metro area. And last year, we were actually given a grant by the Colorado Department of Public Health and Environment to put together a comprehensive watershed plan for Lower Bear Creek. And Lower Bear Creek is one of your finer amenities in Lakewood, as well as in Denver, as well as in Sheridan. So we've had a very unique opportunity to bring together a number of stakeholders who value this as a place for recreation and value this as a natural area that really adds quality of life as well as resources for economic development. In the handout that I'm giving you right now, you will see one of your new council members, Shakti, who earlier today was actually out in the field helping us conduct some water quality sampling, as well as being a chemist in the classroom afterwards. I would like to say that it has been a really tremendous honor to work with a lot of the staff in Lakewood. We've worked with Public Works. We've also worked with Parks and Rec staff, as well as staff from Bear Creek Lake Park. And they have been instrumental in providing either resources or guidance about adding information to our watershed plan. This watershed plan is actually going to be non-regulatory, so these are communities who come together because they value the resource and want to make sure that urban water is clean so that we have access to it for recreation and so that we have a beautiful place to walk. Lakewood is by far one of the communities that has the most beautiful greenbelt and park system along Bear Creek, and I hope if you haven't had an opportunity to be there, that you visit that as well. The goals of the watershed plan, then, are to make recommendations for those communities in Bear Creek that Bear Creek flows through to help maintain water quality. We will also have an education and outreach component whereby we share with communities why it's important to dispose of hazardous wastes appropriately or to minimize fertilizer on lawns. We also have a great opportunity to really educate. We had one event this summer, Fair at the Bear, in which we invited communities from all of the watershed to learn, to participate, to kick up some bugs, to make some artwork, and really enjoy this amenity that we all share. We are hopeful to continue distributing surveys to community members. That's how we get community feedback. We also have a number of Lakewood staff who are involved in the review of the draft that we'll be submitting. And I would just like to thank you all for the opportunity to speak with you and share some of the good work that's happening in your community. Thank you.
Thank you. Great pick, Shakti. Waiters and goggles. Getting right into it on her first day on the job. Okay, David Block.
Mayor, Councilman, I feel that what I have to bring up is so small, and it's a suggestion, but on October 29th, I did something that I've been doing for about 8 years, coming to a facility to give a seminar, and I oftentimes have a lot of books, and I go down a ramp, and I go up to the place where I give my facility, and then I come back, get back in my car, and park it. Well, during this one day, I got a ticket for parking in a handicap slot. And this ramp is the only access into the building at 355 South Teller. So when people have heavy equipment like UPS or FedEx, they have to go down that ramp. So what I do, and I've been told to do this, I turn my car around, I have a dolly, take all my stuff, take it up. And 10 minutes later, I came down. I had a ticket for $115 for parking in a handicapped slot. My suggestion is that we just take this one little area and we mark it for unloading, so merchants can unload and not be penalized with a fine of $115. That's it. Thank you.
Thank
for
you.
allowing me to share.
We'll take a look at it. Thank you. Anita Springsteen.
I'm going to need the projector, so am I ready? We have 3 neighborhoods represented here tonight: Newland Street, Virginia Avenue, and Flower Street. I'd like people to stand up who are here for that, please. And these are the neighborhoods who are getting the equivalent of a Walmart placed in the middle of our neighborhoods. One thing I wanted to bring up about the developers that you were discussing earlier, you didn't say anything about the 2 lawsuits for negligence and other lawsuits against these people. So what about that history? The Colorado Department of Public Health and Environment are the people who license these group homes. There is no record of any license applications for any of these homes that we can find. To say that nothing has changed with the zoning law is not true, and saying it doesn't make it true. The special use permits were taken away, and I know that you say that you couldn't have not issued the permits even with requiring that. But at least it was one more step that the developers had to take. And it meant something because all these developers bought these properties at the end of March of this year, right before the April 1st change went into place. We believe the zoning changes that were made were purposely made to benefit developers like the ones building the group home on Newland Street. For instance, previous zoning code required 65% open space and now only requires 60%. Previous setbacks on the sides were 15 foot, now they're only 10 feet. We want to know who stood to gain from that. And you keep talking about, I want to show you a picture of this thing on my block. I don't know if you can take that out a little bit. But you can see, I mean, it takes up the entire lot. It's ridiculous. And then you're talking about no gray area in the law. Well, Mr. Cox's law firm wrote a guide to considering regulatory programs for group homes that I found. And on page 4 of that guide, it does say that not all courts have concluded that special use permits are discriminatory. So a lot of municipalities still have these in place. And with respect to registration programs, for instance, let's turn to page 7.
I'm going to grant you extra time, Ms. Springsteen. Please continue.
Thank you. On page 7, a registration program can be instituted, which is merely designed to obtain information from the group home to determine that the home qualifies as a handicapped group home protected by the Fair Housing Amendments Act. And you can require things like name and address, name of operator and contact of persons, maximum number of persons to be housed, description of disabilities or handicaps of residents, number of resident staff and hours staffed, physical changes to the premises, etc. Then at least we would know something. Page 7 also says whether special or conditional use permit should be required. Some federal courts, and it is underlined in the guide. I didn't underline some. Some federal courts have found conditional or special use review and other permitting procedures to be discriminatory, but not all. And if a limitation on page 6, if a limitation on the number of residents of a group home is desired, the local government should assess the degree of risk acceptable to the government concerning legal challenges. Although limitations in the number of federally protected persons may risk violating the federal law, there's simply some point at which a group home is of a sufficient size to present a significant impact on the neighborhood. And I do think that character of the neighborhood is important wording here, because what does that mean? What is the definition of maintaining residential character of a neighborhood if not putting in single-family residence homes, not institutions, not hospitals, not Walmarts? And finally, in Mr. Cox's guide, it says a permitting system can provide for reasonable restrictions designed not to exclude group homes for handicapped persons, but to ensure their safety and enjoyment of the residential neighborhood, and can provide for architectural design guidelines imposed to screen or buffer certain features which are often attached to some group homes. There are many. State law also expressly requires the spacing of elderly group homes and mentally ill group homes at a distance of 750 feet from other group homes of the same type. That's page 5. Now this is straight from the city, that there is a gray area, that there are things that the city can do to protect us, but has chosen not to do. One of the biggest issues I wanted to talk about tonight as well is that I spoke with a lady who runs group homes, and she told me that this is ridiculous to put 12 memory care patients in a home of this size, and she did look at the lot. She said is asking for trouble. She said whenever she built a group home of this sort, she always involved the neighborhood. It is a red flag if you don't. And that it's very difficult. It's a very difficult population of people to keep safe, and that it requires one staff for every 3 people, and that this home should have no more than 4 to 6 people in it. And you know, if that were the situation, if this were a single-family residence and it only had that many people in it, I don't think we'd be here tonight. I think the issue is that it's not like any other house in our neighborhoods, and saying it doesn't make it so.
I'd ask you to wrap up your comment.
Okay. I mean, my final comment would be the reason that I moved to Lakewood, and I grew up in a rough part of Denver, and Lakewood was kind of the promised land for me. And I saw this as the place to go, to have some space around me, to have country, to feel safe in my neighborhood. And I looked for a long time for my house, for a year, and probably paid too much for it. And I wanted it because it felt like such a charming and quaint neighborhood. And the reason this is emotional for me is that it's just been pulled out from under me. That is not my neighborhood anymore. Now it's going to be back-to-back traffic, unsafe for my toddlers to go in the front yard. It's going to be parking problems. It's going to be emergency vehicles. It's going to be visitors.
Ms. Springsteen, can you please wrap up?
It's just not
I've
what it
granted you
once was.
much
Thank
time.
you.
Thank you. Good job. Thank you all. Ms. Hodson, we have, let me ask you something. As I indicated earlier, the Planning Commission, as part of their overall recommendation the other night, right? Ms. Harrison was on the Planning Commission. As we looked at our promised update, 6-month update of the zoning ordinance, is passing along, and narrowing the entire zoning ordinance down to the group home issue, is passing along a recommendation to City Council to add notification the way that we used to have it. There clearly are a lot of issues with group homes, and I think I would ask that we do a study session on this issue right now. Let's talk about scheduling a little bit. Okay. We're scheduled for first reading on December 9th and of this zoning revision, and second reading on January 13th. So there's a couple of options here. One is to do a study session at, say, 5:30 on before the meeting on December 9th, do a public study session. Wouldn't be public comment, but it would be an opportunity for council to delve into this issue a little deeper, and there are clearly complexities. And then if we did that, we would have two choices. One would be to do the first reading that same night, but it seems like the better option might be to take some time and do the first reading January 13th and the second reading January 27th.
That's right. We can do that if you'd like. So we can spend time on the whole review and modification of the new zoning ordinance through a study session on the 9th, and not take action, not first reading. Initially, we had planned to do first reading on the 9th of December and then second reading at the next regular meeting on the 13th. So what we could do instead is a study session before the regular council meeting on the 9th, and then have first reading on January 13th. So that gives you ample time to talk to constituents, talk to each other, etc. So that would be first reading on the regular meeting January 13th, and then second reading and the public hearing on January 27th. Right. So that delays
That's the downside, is a 2-week delay, but we get more opportunity to analyze the issue. So,
yeah, and
Ms. Springsteen, if you're still here, by the way, thank you for correcting me on the special use permit aspect of the change. You were correct and I was wrong. I think we do that. There's clearly a little more than meets the eye here.
Sure, we'll adjust the schedule if that's what you'd like. We're happy to do that.
So 5:30 study session on the 9th, followed by a 7 o'clock regular council meeting that will not contain the first reading of this ordinance.
No, and the first reading then would be, again, January 13th.
All right. And now I'm going to plant a seed, and so I've been at this a long time on Planning Commission and City Council. I've spoken about this before. I have a group home in my neighborhood, 5 or 6 houses from my own, and my neighborhood certainly reacted in much the same way, and so I understand the concerns that are being expressed. And we do take this seriously. I want you to understand that we do take this seriously. This is about adhering to federal law and trying to balance that against the needs of a neighborhood. That's what we struggle with up here. So there's no There's no ill intentions. There's no mendacity. There's a lot of people here struggling to try to make this the best it can be, to try to find a solution. So please understand that. And if it takes a little more time to do it a little bit better, I think it's worth it. Okay. I'm sorry I turned this off here. Any other comments at this point, Councillor Paul?
I just had a quick follow-up.
No, we're not. We are not done with public comment.
In the essence of time, when we go through this first reading, second reading, I'd like to maybe explore the possibility of creating it as an emergency ordinance to have it enacted in a more timely manner. And I guess that's up to the council. We really kind of shied away from that in the past, but this might merit a discussion on that.
Tim?
That's something we can look at under our rules. There are still 2 readings, but the ordinance would become effective immediately and not wait for the 45-day period. So we can look into that.
Okay, and I'm going to ask that we at least think about going back to the neighborhood meetings, the required neighborhood meetings. And I know there's some courts out there that don't agree with that, but I would ask us to think about it as adding to that recommendation from the Planning Commission. And I know you're not going to like that, but
just to follow up on some of the comments made by Ms. Springsteen, we've never said there are no gray areas. We recognize there are courts that have not ruled in this area. The 10th Circuit is one that has not spoken on some of these issues, and we're part of the 10th Circuit. I spoke to the author of the guide, one of my colleagues, who I consider an authority in this area, and I would agree that with everything that Ms. Springsteen quoted from the guide. I spoke with him just on Friday and confirmed some legal advice that we'd provided. And again, Mr. Mayor, as you know, we provide legal information and advice to the various departments. We do so based on an assessment of risk. We advise on various options. We don't dictate this is the way it must be or there's only one way to do it. We look at a cost-benefit analysis for the city, for the taxpayers as a whole, for the risk of litigation. All of those factors we look at in providing the advice, and the staff came up with the draft that it did and moved it forward. That's not to say it's the only way to go. It's not to say it's the only way that things are done in the metro area. There certainly are cities who have a different approach. We did not very long ago have those requirements, and
in terms of meetings,
notice, and so on.
Right.
So we can certainly continue to advise staff on whatever options the council wants to consider.
Okay, thanks. All right, let's continue with public comment. Karen Bushlack, please. Could be Bushlack. I'm sorry.
My name is Karen Bushlack, and I live on Newland Street. I'm here just to talk about the definition of the group home. Travis said the only changes were the special use permit and the notification of residents. Well, that is incorrect because, and I need to use the.
Yeah.
Okay.
It takes just a second.
Okay. So here's a definition of a group home that was in the old zoning ordinance. It lists specifically what it is: elderly persons, home for the handicapped, and then it also lists group living quarters, and also here's a group living quarters. This helped the residents know exactly what a group home is or a group living quarters is, and also a residential health care facility. And now there's a residential health care facility, and now with the new zoning ordinance, you guys grouped it all into one. And that's not protecting the residents of Lakewood. The old zoning ordinance protected the residents of Lakewood. So with this new building being built on Newland Street, I feel that it actually is a residential health care facility, because the group home in the past zoning ordinance meant people that didn't require medical help, medical assistance. With this new building on the group home on Newland Street, It's going to be a memory care, as far as we know, and it's going to require medical attention. And with this residential health care facility, they're not supposed to be in a single-family residence home. A group home never was specific to the memory care folks. If they didn't need medical help, then it wouldn't be in a single-family home. So, like I said, the zoning ordinance was rewritten. It no longer protects the residents of Lakewood. It was more detailed on what exactly a group home meaning is. And this home is going to hold up to 12 residents. And what about the staff members? Like Anita was saying, for 3, you need to have 1 staff member. That's going to be, 12 plus 4? That's going to be 16 people there. They can't have 16 people living there. It's only supposed to be up to 12. In the old zoning ordinance, they had up to 8 with 4 staff members. And I'm okay with that, but you all changed it to allow up to 12 individuals. The home is being built on, let's see.
I'd ask you to wrap up your comments, ma'am.
Okay. So when you guys are going to discuss the group home, you might want to look at the old zoning ordinance and see exactly what the group home really meant in the past old zoning ordinance, because it didn't mean residential health care facility, which is being built on Newland Street, because that should not be in a single-family home residence. It should be on a duplex or anything other than a single-family home.
Thank you. Kathy Mays? Kathy Mays? Dale? Yeah, thank you. Well, there's a whole list of folks here, so. Dan, I think virtually everybody signed up. They'll have an opportunity. And if they didn't sign up, they'll get an opportunity anyway. Don Bathrick? All right. Julie Williamson? Anything to add? All right, come on down.
Mayor and City Council members, thank you for listening to me. I live in the 1600 block of South Newland Street, which is not, it's a block farther south in the Sanderson Creek Homeowners Association district. We have a group home that's located just outside of the opposite side of our development. It handles other types of disabilities, people who have drug problems, mental problems, and so forth. And it has been an absolute nuisance to our residents because of all of the emergency equipment, people running around in the streets in the middle of the night talking to themselves. And I have serious concerns about having another group home in our area that houses even more people and will require more emergency equipment, utilizing all of our city resources for things like that. And I'm wondering if the council has considered charging these group homes when they have outlandish numbers of calls that are maybe false alarms. They charge homeowners when they have false alarms, and they respond more than, I don't know how many times, I believe it's 3 times to a false alarm at a home. And I believe that the owners of these group homes should have to pay for our resources. And I would also like to know if any of you have driven by any of these locations where they're building group homes and taken a look at them. I mean, really, it's outlandish, the size of the one that they're trying to build on Newland Street. It's ridiculous. Thank you.
All right, thank you. Edna Rick Schmidt.
I'm Edna Smith. We live at 855 South Flower. There is a proposed group home next door to us. We thought we were building in a lot that was a single-family dwelling area in Belmar Gardens. That's what we were assured of when we bought our lot. This group home is supposed to be 5,500 square feet under roof and a basement that size. That does not compare with any other homes in our block. They're all around 2,000 square feet. The traffic is concerning me greatly. You have 12 people in there, and the help, there is no parking. They have 2 parking places on their property. What are they going to do? Have parking on the street? All the street will be filled with cars up and down the street from people working there, delivery people. Delivery trucks are notorious for not obeying 25 miles an hour speed limit. We have children on our block. They'll be running out between cars. That's going to be a problem. Thank you.
Thank you. Mr. Smith?
Can I have the projector? I just wanted to, I live at 855 South Flower Street with my parents. I was born and raised there. My father built the house 50 some odd years ago, and as she states, this is the other home of the builder that is building next to my folks. My folks' house is 1,200 square feet. 1 bathroom and a half, 3 bedrooms. Does this look like a comparable or a supportive structure? Please come and drive up and down the street. Come and sit on the driveway, have a cup of coffee. The biggest house on the block is 2,000 square feet. This is over 5,500 square feet. What's going on next door is 5,500 square feet. How can Pete Roybal, we had a neighborhood association meeting. We all sat and talked. We were told, don't speak up.
Maybe go over to the mic. Yeah.
We were told, don't speak up. It's discrimination. It's a protected class. You guys can't speak up. Well, who's going to protect this class? Belmar Gardens is predominantly over 65. My folks, you can see most of them around here, but they're told not to speak up because they'll get sued for discrimination. Well, who's going to protect them? They have paid into taxes from City and County of Lakewood. I'm 46 years old. They've paid taxes there for 46 years. They've paid it. This is their retirement. These people don't even live in Lakewood. Why give them anything? They don't live there. The man that owns this, he lives in Aurora. He gives his money to Aurora. But you guys, the city of Lakewood is giving him property and giving him rights and ruining the houses. The houses in the neighborhood are probably $170,000 to $200,000. After this goes in, are those property values not going to be affected? They have 2 parking spots. Look at it. That's my concern. And, I'm 46 years old. I have my own life, but that's also my parents. And I have to take care of them. I can't take care of them next to this. Thank you.
Thanks. Kent and Marcia Lina, do you wish to speak?
My husband and I built a beautiful new home, and we are so disappointed that this is going to happen to our neighborhood. When we built our new home, we thought that we were going into a neighborhood where there would be other children for our small child. That's not what's going to be 3 houses down from us. The mailbox is straight across the street from this group home that's coming in, and the street T-bars. We're cautious now when we go to get our mail because of the traffic there. Now, this group home is going to be sitting right there across the street from this mailbox. There is no way that I'm going to want my child to go up to our mailbox anymore or to the corner of the street. There is going to be traffic. There will be no parking there. We built a large home, so I can understand that they're putting a larger home up there. We're on Virginia, and it's a new area that was built right across from Manbrook Park. What I think is going to happen to our neighborhood is going to be sad, and for the children. But we have a lot of pride in our home, and we take care of it, and we want it to be enjoyed by everybody in our community. We share our home, our landscaping. There is nothing for landscaping to be on. There's not even a driveway where a full car can sit on the way they've done the easement to the sidewalk. So any emergency vehicles, any parking, it is all going to be on the street. And I beg you all to go look at where these homes are and ask yourself, where will my guest park? Where's the ambulance truck going to sit? How are we going to get through here? And it is a big, huge issue. But we just look at, this is our future. We invested in our future, in our home, in our community. And we are very sad what's occurring and how these people who can come in and do this. And I can tell you that there are neighbors, new neighbors that also built, and they've used this builder. They cannot speak here tonight because they are going into legal with them, the maintenance of the home and the stuff that they were told to do. So there's also going to be maintenance issues with these homes they're building because this builder is doing some bad work, and they won't take my phone calls. I was calling them before I ever knew of any of this stuff going on about how they were building some of these homes. Because we built $1 million home. That's what we invested in our pride in our future. And they're building these homes that are not good buildings. So they're going to need a lot of maintenance and a lot of work. And they're having problems having people come out to follow up to do their work. So they can't speak tonight, but I implore you, please, look at what they're doing to some of our neighborhoods. Thank you.
Thank you.
Happy Thanksgiving.
Thanks. You too. Steve DePaula.
Thank you for the time, Council. I also live at West Virginia, and I'm here to talk about the safety issue as a healthcare provider. Myself, I look at this, and I look at the residents not only in our community that you just heard about, but the residents of this for-profit healthcare facility that will go into our neighborhood. We have narrow streets. We have very poor lighting in this neighborhood. We have the traffic at the mailbox. Right now, you can't safely walk down this street now because of poor lighting and traffic flow patterns. So I fear for our community's safety, and I also fear for the safety of the residents of this facility. In our neighborhood, it's really not a safe environment, and I would ask people to reconsider that given the safety of the children, the residents, and the future residents of a home like this. Thank you.
Thank you. Did Sandra Young speak already? Yeah, I think so. I know Don and Kathy were up here. Okay. Charlie Abel.
Good evening, Mayor and council members. I welcome our two new council people, and I welcome back our re-elected 3 council people. My name is Charlie Abel. I'm a Ward 1 resident, and I'm here to talk about the truth. Already tonight, we've been told that the zoning rewrite changed nothing about group homes. That field lasted about 30 minutes. A few weeks ago, a citizen asked the mayor how many metro cities have as many pending applications for large group homes as Lakewood does. The mayor responded by asking our planning director, Mr. Parker, how many area cities have group homes? That response was an evasive sham. Why don't you want to answer that question truthfully, Mr. Mayor? And when citizens in the press asked Mr. Parker about the group home issue, he confines his answers to requirements surrounding the smaller group homes of 8 residents or fewer. That's not the issue. Mr. Parker fails to mention how much wider regulatory power cities hold when it comes to the larger group homes, housing 9 or more people, which are not required to be allowed in every residential zoning category, as are the smaller group homes. Those are the group homes. The larger ones are the group homes in Lakewood tonight. Why not tell folks that it was the City Hall rewrite of the zoning ordinance that caters to these neighborhood-busting, out-of-place large structures? Operators of the group homes that dwarf houses next door and destroy single-family residential character of neighborhoods by increasing density are no more welcome than any other bad neighbor. This resulting increased density seems to be City Hall's goal. Recent city surveys asking citizens how to accommodate more density in our established neighborhoods, increase our concerns for the neighborhoods we love. And how many of you council people told voters they would that you would eventually represent that you would endorse increased density in the neighborhoods? I don't think any of you told them that. When we're critical of city government, some of you wrongly cast us as people who don't love our city, that we don't like Lakewood. You're wrong. We love our city and its neighborhoods. If you love Lakewood also, why are you trying so hard to change its character? You folks are public officials and owe the public the truth, all of the truth, not half-truths, and certainly not disrespectful responses to our questions. Thank you.
Thanks, Mr. Abel. Edie? Brian?
People up there that had already spoken asked me to remind you folks that before these hearings that you're going to have on the amendments to the zoning ordinance, a lot of construction can be done on these buildings.
Right. That's why I brought up the 2 weeks extra time, Charlie. I'm aware.
I'm Edie Bryan, and I live a block away from the existing group home that was mentioned previously, and about a block and a half away from the new under construction so-called group home on Newland Street. I don't think you realize the gross scale of this building. How many bedrooms are in most houses in Lakewood? There might be a few houses that have only 2. 3 is probably the norm. 4, some, especially those that have converted a basement into bedrooms. And there probably are a few exceptional ones where there's a really huge family or other circumstance where there's 5 or 6. This structure is to have 10 bedrooms, 10 baths, plus 2 bathrooms for the handicapped. What the other handicapped, and this is supposed to be for the handicapped, what the other handicapped people are supposed to do who don't have the handicapped bathroom, I haven't figured out. There is no porch. There is no room for a garden or even a path around the house. And this is supposed to be a home. Now, if there are 10 bedrooms and you put 2 people in a bedroom, which is pretty normal for Lakewood, I don't think there's a lot of that effect, but that's a pretty normal number. That's 20 people. If you then put in 2 bedrooms in the basement, which is pretty normal for Lakewood, you then have 24 people, and we haven't even gotten to the staff. This is not typical of Lakewood. I appreciate the fact that you are starting to look at some changes, but in the meantime, this thing is going up. They have a building permit, and the city has failed to even reconsider it. I will say one thing nice about the city. Upon the complaint by Anita Springsteen about the mess that the construction site was, and not only the site, but the street in front and adjacent, that has been cleaned up. I don't know who did it, but I assume the city did exert some pressure on somebody, so it does show that you can do something, because it is a lot better. I won't say it's a great construction site, but it's a lot better. This is not a home, and the present zoning ordinance does differentiate between group homes that have 8 and those that can have up to 19. And 19 is not a typical Lakewood home.
Thanks, Edie. W-A-U-G-H, Kelly, pass, all right. And then Grant, I think it's Grant. Gnert, something.
Actually, I'm LaJonna Waugh.
All right.
I live in Sanderson's Creek, and we do have a group home on the corner, and there's going to be another one built. When you guys do your discussion, I would really like you guys to drive by because they're so close together. How close can these be? We already have one, and we have them running in the streets at night. They're not well contained. I don't know how often, especially on the weekends, I don't know how often somebody is there. There is some problems with that one. But if we get a larger one, and it's so close, I think that's the problem too. I don't think people didn't realize how many people were going to stay at the one that's a home. They say that there's 8. Sometimes I feel that there's more than 15 kids out there smoking. I guess my main concern that I want you guys to look at is when you guys do have your discussion, how big can these places be? How far apart can they be? Because now we have 2 in our neighborhood. 1 block this way, 1 block that way.
Thank you.
It's not fair to my grandkids.
Thanks. Anyone else in chambers? Come on down.
Hi, I'm here on about the structure on Newland Street also, and as we've heard tonight...
Could you just identify yourself?
Oh, I'm sorry. My name's Debbie Doyle.
Thanks.
All right. And as we've heard tonight, this issue is not about group homes as a concept, and it's not an issue about not in my neighborhood. This is an issue about the size and therefore the sustainability of the proposed house in the existing neighborhood. At the last council meeting, City Councilwoman Wilson commented, well, what should we do about the elderly and those in need of assistance? I don't believe that warehousing the elderly or the disabled or those in need of a rehabilitation is a good solution. Building a commercial venture in a residential area and calling it a group residence does not make it so. This is a commercial venture to warehouse residents in a location with inadequate services, inadequate room to provide for the residents, and inadequate infrastructure. I don't believe the City Council has acted in the interest of the neighborhood, and it's not acted in the interest of the residents who would go into this group home. I have not seen proper steps taken to ensure the proper usage of the building or consideration for the quality of the life of the residents that will be in the building or of the neighborhood. And we've heard parking several times. It seems to be kind of a trivial issue, but it's an issue that affects safety, and a lack of the adequate parking for the number of residents on the proposed street will affect that safety, especially on Newland since it doesn't have any sidewalks. I would like to know what the City Council plans to do to mitigate the risk generated by the inadequate parking, and if there's going to be an analysis of how much additional parking would be needed to support the number of residents, employees, service providers, suppliers, and vehicles needed for the residents themselves to transport them to different places. And we've talked a little bit about the regulations and that most of the regulations are on the state. But since this group home is going to have this many people, what are the regulations at the state level, or I'm sorry, at the city level? And is the City Council part of the regulatory agency? How do you ensure that the number of caretakers per the number of residents is adequate and that their training is adequate? And how do you discern between the level of disability, somebody who's wheelchair bound, that has no ability to care for his or her own needs, how many caretakers are required for how many residents of that level of disability? I don't think you can have 10 people with that level of disability and only 2 caretakers. So how are we going to enforce that ratio? How are you going to determine the disability severity and the number of caretakers and the caretaker training? Thank you.
Thank you. Anyone else?
Mr. Mayor, members of the council, thank you for giving me an opportunity to follow up. Firstly, I would like to thank Ms. Johnson for graciously addressing my concerns. Mr. Mayor, to you, I'd like to say that you're correct that ICCS does most of their work.
You've already spoken on this issue.
Following up,
We'll have a conversation offline. All right.
Is my time up?
Yes.
Clerk, I have 3 minutes.
We've already spoken. Do you want to talk about ICCS? You've already spoken about it.
Am I not allowed to follow up?
No, sir. But you're happy to. I'll give you my cell phone number. I'm happy to talk to you about it. All right, Kathy, and then let's wrap this up because I think you all deserve some feedback. Anybody that sticks around. All right, so then we'll close public comment. All right, I would ask a lot of folks, and I know it's late, but I think it's this is a community conversation, so stick around.
Good evening.
Hi.
Thank you. I guess I took the long way. Sorry. Good evening, and congratulations to the newly elected and re-elected council members. Tonight's your night to celebrate, and now to get to work. My name is Kathy Kentner, and I'm here tonight to offer a real practical solution to an issue. I come to you tonight as someone who can relate to and understand both those of you on council and those of you whose neighborhoods are being afflicted with these large facilities. I'm most definitely not a NIMBY, not in my backyard, as former Planning Commissioner Urbanowski likes to refer to those of us who ask questions. None of these homes are currently planned for my neighborhood. But I am also not in the spotlight, as you are, and not prone to dismissing well-thought-out, intelligent comments as some city staff and officials do. I've listened to public comment on the group homes issue and the vague responses that do anything but answer the questions. And then I did what many of you know I tend to do. I read. The main question I've heard is, what can we do? And the very misleading answer has been, nothing. Although Travis Parker is quick to say that he cannot deny these group homes, and currently he is correct to say that, the reason is not due to the Fair Housing Act. The reason is due to language in our new zoning ordinance. This language can easily be changed so that our ordinance is still well within the parameters of the Fair Housing Act. Not only that, these changes actually improve quality of life for future group home residents and make group homes more in line with the vision that we all had when this ordinance was passed last year. First, I asked you to consider changing the definition of group home. As it is written now, we've only been talking about the elderly and disabled. However, as it is written now, group homes of up to 8 can house any group. In my neighborhood, that's likely to be college students. Another example somebody gave was troubled teens or convicted felons. The only thing we can stop is that we cannot have more than one sex offender. But next door to me or any of you could go in with this definition, a group home for convicted felons, with only one sex offender, though. Next, please change the use table so the group homes of 1 to 8. I'm sorry, I didn't tell you my solution for that, though. Please specify in the definition that group homes are for those that are protected by the Fair Housing Act. Next, please change the use table so that group homes of 1 to 8 residents are permitted use in all residential districts, and that group homes of over 8 are permitted use in all multifamily and multi-use districts. That is, remove group homes of over 8 from single-family districts, as this is allowed by federal law. One last comment. I sort of heard a vague answer to Councillor Johnson's question. And no, currently we do not have anything in place to address size in regards to character, but I actually read quite a bit about that, and it seems to be upheld that, it's for all of us, though, so that nobody, not just a group home, but nobody can build a home that's so out of character of the neighborhood. I didn't have any time in my 3 minutes to address that, but hopefully
Thanks,
when you all have your study session, you'll do that. Thank you.
Thanks. Okay, we're going to wrap up public comment. Oh, Heather, when did you come in? You been here all night? Oh, okay. Welcome.
Good evening. Make sure I can see my time. I'll find the beginning here. Okay, so I'm Heather Wenger. It's good to see you all tonight. I'd like to welcome back 2 of the most independently minded board members, David Wickman and Ramey Johnson, for their second terms. Dave and Ramey earned a lot of admiration and a lot of votes from listening to their constituents and standing up for a responsive and transparent city government. I'd like to also welcome 2 new board members, Shakti and Karen Harrison, tonight. Shakti and Karen, we very much hope that your time on the council will be marked by the same level of commitment to transparency and responding to the citizens that David and Ramey's has been. As you heard tonight, there has been, gotta lose my train of thought, I'm sorry. As you have heard tonight, there are a lot of citizens who are tired of having measures that negatively affect their lives and homes moved through City Council with, those measures have already led to confrontation between the city government and its citizens in the form of successful petition drives and a lawsuit. We hope that both of you choose the path of cooperating with the citizens instead of the path of political and legal conflict that has characterized the council's actions in the last several years. Now, listening to the conversation earlier, I sincerely hope that the change in dates on the study session and the first and second readings about the group home issue and the amendments to the zoning ordinance that was passed in December, enacted in April, indicates a true willingness on the part of all council to consider the citizens' input. Only time will tell on this. Along the lines of suggestions and questions, one follow-up question. There was a gentleman up here in a blue shirt earlier tonight. I don't know if he's still in the audience. He had a question about what happens with these homes if they get sold, and it's not the developer anymore. It's not the original use anymore. The West Virginia Avenue group home actually has a for sale sign in front of it right now, so that leaves a big question mark in my mind, and I'm surprised that nobody else brought it up tonight. But why does it have a for sale sign in front of it if it already had a plan and it is only foundation? And then suggestion, Mr. Paul, you asked about an emergency ordinance tonight, and I thought maybe we were going down this path, but it ended up being just the second reading and stuff. Are you able to consider doing a motion for a moratorium on new permits between now and the second reading? Are you able to do that tonight to sort of do the stopgap for that 2 weeks that was mentioned about extending the time? Could you also do another one that would pause, I don't know the legalities of that, but pause the existing permit until you're able to further research the man's credentials?
Thanks,
Thank you very
Heather.
much. Have a great Thanksgiving, everybody.
Thank you. You too. All right, we'll close public comment. Let me offer a couple things up. Heather, of course, we've seen here many times in relation to the issue at 2090 South Wright Street. That issue, as we know, is sitting with a judge in Jefferson County District Court right now. We will have a ruling at some point in the relatively near future. Whichever direction that ruling goes, there will certainly be opportunities that I hope everyone takes advantage of to get together and really have, again, some community conversations. I think there's, again, no matter how the ruling comes out, there have been some ill feelings and some harsh words all around, and not just neighborhood and staff and council, but the entire. This is an issue that folks around the city have been watching, and not everybody's been feeling too good about it. So I think when I took this chair 6 years ago, I talked about civility and the need for that, and I think we've largely done pretty well, and I think it'll be time to use that as a goal in re-energizing community conversations amongst all of us. So I extend that offer no matter how this comes out. I think it's something that we all would very much want to do. Back to the group home issue, I just want to assure you once again that this city council wants to do everything it possibly can. We understand that this is a serious issue. We are balancing, staying within federal guidelines. We have to adhere to federal laws, and we need to balance the concerns of all of the neighborhoods of Lakewood, single family and others. So that has been our goal, and that will continue to be our goal. The fundamental assumption, the foundational assumption here is that a group home and a single family home have the same rights under the Fair Housing Act. That affects sizes. We can't limit the size of a group home without limiting the size of a large home that somebody else builds, right? So, these are the issues that we're going to have to wrestle with as we move forward on this. Heather brought an issue that is not new, and I'll just bring it up here. This idea of some sort of a moratorium between now and then. We actually talked about that a little bit earlier. And I'll just turn to Mr. Cox. I think that's pushing the envelope, but a moratorium on there are two separate issues. One is on new applications, and one is on existing permits. And talk to us.
Right. Well, I'll consult with the building official again, but we looked at the possibility of holding or suspending a permit, and I have concerns about our ability to do that. In terms of a moratorium, I think the council has the legal authority to impose reasonable restrictions on applications of a certain type. In some cases, it's used for all zoning land use applications when there's a zoning rewrite in the works. We did not do that in the case of the new zoning ordinance this year. But that's a technique that is valid. My concern about the proposal that you embark on that tonight by motion is that, as we've talked about throughout this process, there's been no notice. There's no indication to anybody who's got an interest in that process, applicants or anyone else, that there might be a consideration and an opportunity for them to be heard on whether a moratorium is appropriate.
Is it a resolution or an ordinance?
if you're imposing a freeze on the function of an ordinance, if you're taking a section of the code or one or more sections of the code that provide certain processes and you're changing those processes, it really should be done by ordinance. We have done moratoria by resolutions in the past, so it would depend on what exactly we were looking to preclude or prevent in the interim.
All right, I'll be specific and help me out here, Tom and Karen, Shakti, our attorneys. And again, look, I'm just thinking out loud here, okay? Doing this without a net, by the way, live on television. So a moratorium on new applications for group homes.
Well,
A, resolution or ordinance. B, you said earlier you assess levels of risk. Kathy? Yeah, go ahead, guys.
Yeah, and would it matter if we looked at, because clearly the issue are the larger homes with the more than 8 people. So looking at it as a moratorium, right? Because it seems to me that the smaller homes are not the issue. It's the size of the homes and the number of people that's really the issue here.
Yeah, well, I think in either case, again, the authority is there to impose those kinds of limits and reasonable time constraints on them. The same concern would exist regarding notice to interested parties tonight, but certainly within that set of applications or that set of proposals, we could impose a moratorium.
And would it help at all if we did a moratorium and then put it out there for public notice to have an opportunity to have a hearing on it within a couple weeks at the earliest possible time?
I'm a little concerned here about procedural due process.
Right.
We don't want to get ourselves into that boat. And if we impose that moratorium without adequate notice to the community and to people who operate and want to open group homes, we are definitely exposing ourselves to a lawsuit.
Yeah, I'm not sure if a cure like you proposed or post-moratorium procedure for notice and hearing, I'm not sure if that would get us past the concerns that Councillor Quinn has raised.
So it would be done by ordinance? Is that your opinion?
I believe the most effective method is if we're preventing someone exercising rights that are granted by ordinance.
That are enabled by an ordinance. It would have to be restricted by an ordinance.
Now, it's also a question of timing. The shorter the time period, the less of a restriction on rights, but I still think that an ordinance, suspending an ordinance is the most appropriate way to go.
Is there a potential unintended consequence of a sort of Oklahoma land rush to apply for permits in the intervening 6 weeks here? I guess that's purely speculative. I withdraw the question. I think that if we do this, it would have to be done via ordinance. And given the schedule, there would be a first reading on December 9th and a second reading on January 13th. And and given the fact that we're looking at 2 weeks later, I'm not sure how effective this strategy would be. Karen, Adam?
One of the things that was raised was some of the quality of the construction going on. Is there a way to increase the level of supervision, so to speak, or make sure that the review is there, that we're getting the construction that has been permitted?
That's a function of the building department inspection schedule. Certainly, if they're notified of a particular concern on a property, they would go out and do additional inspections to make sure that the standards were being met. But beyond that, they'd follow what the building code provides for inspection and review.
Right, so if the residents noticed something going on that didn't seem quite right and they called it in.
I can't speak for Mr. Clayton, the chief building official, but I'm willing to bet he'd have somebody out there as soon as he could to look into it.
Okay.
Councillor Paul, then Councillor Quinn.
Thank you. To Karen's point, I think that it does make sense to maybe look at the 8 residents and above for sure. My question is, could something be done tonight as far as the enactment of a temporary, because we are going to revisit it, so it may be, I mean, it's not going to be permanent, but a temporary, and tonight could serve as first reading. We don't take public comment at first reading, but tonight could serve as that first reading of notice that in 2 weeks there will be a permanent vote on a temporary type moratorium until we can straighten this out.
As opposed to enacting a moratorium tonight, it's putting on notice that this would be equivalent of a first reading to be dealt with at a future meeting. It certainly improves your position. We wouldn't normally take input on the first reading anyway. Nevertheless, I know that the clerk would agree that ordinances and such are placed on the agenda and published for a reason.
Well, and therein lies the conflict. I mean, the city sometimes is criticized for not putting things out there, or there wasn't notice given. I mean, we're just dealt with it recently where folks are very upset. So we kind of, I mean, how do you walk that line? And I look to the colleagues to maybe help me with that. I mean, where do we go?
Tom, I know how Tom feels, and you're next up anyway. I mean, we do live in a democracy, and that includes due process for everyone. Tom?
Yes, I mean, I agree with the idea of looking at a moratorium for group homes of more than 8 people. But I do have that concern about procedural due process. I think we have to do this by ordinance. I think we have to do it the right way, or we're risking a lawsuit. Now, just to kind of add on to that a little bit, as you know, I've been through this before with group homes. One thing I'd like to hear more about is the issue of, and not necessarily tonight, but as part of the process of studying the ordinance, is the issue of reasonable accommodation. Is allowing a group home of up to 12 people a valid, reasonable accommodation, and what does the case law say about this issue specifically?
I'm happy to address that whenever you want to talk about it. I can tell you in brief, because I had the same note, that we had not had occasion to use that phrase tonight. And it's a big part of the law with Fair Housing Act, because the standard is pretty high. I'm reading from a statement developed jointly by the Department of Justice and the Department of Housing and Urban Development, so it's federal agencies responsible for enforcing the FHA. And here's a little sample of what it says about reasonable accommodations. What constitutes a reasonable accommodation is a case-by-case determination. Not all requested modifications of rules or policies are reasonable. If a requested modification imposes an undue financial or administrative burden on a local government, or if a modification creates a fundamental alteration in a local government's land use and zoning scheme, the entire scheme, it is not a reasonable accommodation. So it's the flip side of that is, unless an accommodation creates an undue financial or administrative burden on the city in this case, or fundamentally alters the entire zoning scheme, it probably would not be considered an unreasonable accommodation, which means we have to make that accommodation in most cases. My recollection is that in extending the number from 8 up to 12, staff was looking at the reasonable accommodation issue and increasing by numbers 9, 10, 11, what have you, that there's case law where that has been deemed a reasonable accommodation to allow an extra resident, an extra 2 residents, and staff was looking to streamline the process. But that's certainly a concern that has been raised tonight, and that is a valid issue for us to look at, is the numbers above 8. There's nothing magical about 8. That just comes from some prior decisions as well, but we can certainly take a look at that again.
Something else I would be curious about is going back to prior to enactment of the new zoning ordinance, which took effect in April 1, 2013. Was it our practice to grant reasonable accommodation in these cases, and how often did we do it? I mean, from a factual standpoint, it'd be interesting to know that.
Yeah, I'd say I hope we did have that practice, because when the requests were made, if they were deemed to be reasonable and didn't conflict with that standard that we read about the undue financial hardship. I recall a handful of discussions about reasonable accommodations. It's not something that happened frequently. So I think our goal was to grant reasonable accommodations when they were reasonable.
Thank you.
Just another follow-up as to, can a temporary moratorium be enacted by the director? I'm trying to look in the zoning ordinance. Is that a power given? I know there's powers given. And could something along the lines of a temporary be issued by the director until we have further study without having to enact any sort of ordinance?
I don't think we'd find that express power to start with. But whether it's within the discretion of the director to hold an application for a matter of a couple of weeks.
Could council give that power?
I think council could direct staff to use whatever discretion it has with regard to applications as they're coming in light of the intention to look at a more in-depth discussion of the type of group home that we talked about tonight.
Okay.
Right.
I want the answer to be yes, but, this is, if the shoe were on the other foot, there are folks in this room and throughout the community who might very rightfully say, hey, wait a minute, you're not following your own processes here. So,
Mayor, I have a thought. I wonder if we can't have the study session that we talked about earlier for December 9th. Mm-hmm. I wonder if we can do that on December 2nd. So speed this up a little bit. We just happen to have an update on downtown Lakewood connectivity and urban design plan with the planning staff.
Oh,
so they'll already be here
anyway, right?
And I'm wondering if we're not able to review, and again, I'm just thinking out loud as well, but if we're not able to review, say, the whole zoning update, rewrite, perhaps we can focus just on the group homes piece for the second, and at least we have that conversation. We can do some work on the potential temporary or other kind of moratorium and have some information for you by the second to be able to act on it, at least with first reading on the 9th. I mean, it makes it quicker.
I'm sorry, Karen. Let me just carry that thought out to its logical conclusion. So we could have a study session on the 2nd, probably devoted strictly to group homes. We could still stick with an early study session on the 9th to address the rest of the
balance, right?
The balance of the zoning ordinance.
That's right. Mm-hmm.
We could have a first reading on the 9th.
Specific to any adjustment to group homes.
Well, I guess what I'm getting at is we would have we potentially could have revisions ready for a first reading on the 9th anyway. No, it would have to go to the whole zoning ordinance, wouldn't it? Right. I'm thinking that we might wind up with a second reading on the 13th and negate the need for a moratorium that we couldn't institute until the 13th anyway.
Yeah.
Yeah. All right, all right, Karen, and let's think about any direction we might be able to give to the planning director. Karen?
Yeah, and just a clarification, when we're talking moratorium, we're talking about new permits. We don't have any way to stop someone who already has a permit and is out there building.
That is correct.
That seems like a taking.
That's correct. That would be a taking.
Dependent upon the outcome of the investigation, though.
Well,
if there's another legal basis to take an action, yeah, but just we couldn't do a moratorium and say in the middle of construction you got to stop. That seems like that would be a adverse action.
You would
if there's some legal basis.
We're on it.
Yeah.
If there were some violation were found, some misrepresentation, I suppose a stop work order could be issued or an injunction applied for in district court.
We may have some options there. We're talking about whether there's specific authority in the code for suspending a permit under the circumstances that have been described, and we've not found that. But we're continuing to look at all of the circumstances that have been raised. Mr. Parker was in my office today talking about these same allegations that were raised about the builder. We're continuing to look at it.
So the other thought then is what Margie just brought up, is potentially having a special meeting on the 2nd to do the first reading of whatever this action might be.
The moratorium type action?
Mm-hmm.
Well, could I ask a question about dates?
Yep.
If we did the 23rd, do a special meeting for second reading. Emergency ordinance, it's enacted on the 23rd.
So look,
but I know there's probably...
We've always tried to do things thoughtfully, and this is one that's going to take some time, I think, to work through some of these very complex issues. And again, I think it's more important to do it right than to do it quick. So let's go back to the calendar. A study session on the 2nd. I don't think we can have a special meeting because we haven't really had time to delve into the issues. Yeah, that's next Monday. So we have a study session on the 2nd. The 9th becomes, I guess the question is, can we deal with the whole zoning ordinance on the 2nd? Then we theoretically could have a first reading on the 9th and a second reading on the 13th on the entire zoning ordinance.
Well,
go ahead.
I mean, there could be a lot more to the entire zoning, other parts that probably need further examination.
Pardon me. And another option then is to put off the balance of the zoning ordinance till January and not try to shove all this together potentially. So deal with just the group home issue with a study. And remember, we have a holiday this week too. I mean, that also is another reason to think about this. So maybe we do a study session on the 2nd and on just the group home piece, and we don't try to cram in a review of if that's all right with you.
Yep.
Don't try to cram in the balance of the zoning ordinance because we want to be thoughtful about all of this, right? So then we schedule that January, maybe early February, sometime that fits in, so because you'll need to do first and second action readings on the balance of the review of the zoning ordinance. Make sense? So we'll just focus on the group home issue now.
All right. So that's the path of studying the group home issue and having a first reading and a second reading. So let's take that path. Study session on the 2nd, first reading on the 9th, second reading on January 13th.
That's right.
Now there's a separate question about any department head moratoriums and any authority council may or may not have to do that.
And, I was careful in how we phrased that the last time around. I think what the council could do is direct staff to use whatever discretion it has in evaluating the timing of applications. I'm not saying that the director can unduly delay an application. I'm not saying the council can direct staff to do that. I'm saying there's a certain amount of discretion that can be exercised.
Yeah, and I don't think we want to
but
or can establish that precedent.
Absolutely, but I think it's also fair to the person who may be coming into an application to know up front that this may change and that there could be a delay because of that potential change.
Yep. All right. I'm sorry to have this procedural and scheduling conversation in public like this, but it's very important. And to recap, what we're going to do is, again, last Wednesday the Planning Commission passed on a recommendation to the entire City Council on revisions to the whole zoning ordinance that went into effect on April 1st. That was part of an agreed-upon plan at that time to do a 6-month update. Planning staff did that 6-month update. Planning Commission made the recommendation last week. What we're now proposing to do is bifurcate that recommendation and deal solely with the group homes first because it's a matter of urgency. And we'll have that discussion beginning with a study session on December 2nd. And whatever changes we recommend will be on first reading ordinance on December 9th, and then second reading for final vote and opportunity for public comment on January 13th. Clear? Clear? Get some nods out there. All right. Thank you. All right. January 13th for second reading. And that's it. Again, we don't have opportunity for public comment for first reading ordinance. We don't have opportunity for public comment at study session. We've heard you loud and clear, not just tonight, but through the past weeks. And this is not a rezoning matter, so you're right. It's not rezoning, so you're free to talk to any of us about it. And I mean, individually, phone calls, email, anytime. Even though there's not opportunity for public comment. All right. Pete and Scott.
Thank you, Mayor. This is a little bit of a change here, but it's still group homes. It was brought to my attention that safety is a big issue in the city, and I wanted to bring it to council here and let them know. My question is in these construction sites, do we mandate that the construction site be fenced off, being that there's a hole in there, maybe a little kid might fall in, or the construction site where a kid, if we have foundations being poured, an animal or a kid could fall in and get hurt? Is there some kind of a ordinance or some kind of something that would require the contractor to fence it in?
I don't have the provisions of the building code committed to memory. Bill Clayton does. He's the chief building official. He can tell you on the fly what requirements there are for.
If so, can we bring this to his attention that these group homes, and there's some construction sites right next to it that don't have fencing, security fencing around there?
I'll certainly take it up with Mr. Clayton, find out what the requirements are.
I'd appreciate it. Thank you.
Scott?
Sorry, Mayor. I just want to clarify the date that you're talking about, the second reading, December 6th.
January 13th.
That's January 13th?
Yeah.
I apologize. I thought we were looking at it in December.
No. So first reading December 9, second reading January 13th, which is our next meeting.
Thank you for clarifying.
And again, I appreciate the holiday suggestion. I'm not sure that's fair to anybody involved in this, any of the neighbors or anybody in the industry. So, all right, I think we've come up with a good plan. Adam, anything else?
I was just gonna. 17.1.7 is the director duties, and I mean there's open to interpretation, and number 4 states waive any standard in the zoning ordinance with the exception of any uses identified. Not that a timely review is a standard, but I think it explicitly somewhat says that he can maneuver how he or she can maneuver.
Yeah, we'll have to take a look at that and talk with the director about that.
All right. Well, this has been. Again, thank you all. We're gonna keep working on this, and do the absolute best we can. All right. We do have a little bit of business to conduct here. Well, I'm going to dispense on the instructions on the consent agenda and ask the clerk to read the items into the record.
The consent agenda consists of items 9 and 10 only. Item 9, Ordinance O 2013-26, amending Section 14.25.050 of the Lakewood Municipal Code relating to floodplain management. And item 10, accepting the minutes of the Advisory Commission for an Inclusive Communities Full Commission meeting of September 18th, 2013.
Thanks. I'll now open the public hearing on the consent agenda. Anybody? Actually, we don't have any items to talk about. We got a first reading ordinance, right? So, never mind. I'm ready for a motion.
Mayor Murphy, I move for acceptance of the minutes of boards and commissions, order all ordinances introduced on first reading to be published in the Denver Post with public hearing set for the date included in the ordinance.
Second.
Motion and a second on the consent agenda. Any discussion? Please cast your votes. And it passes unanimously. On to general business. We do have an item under general business, and I would ask the city clerk to read this motion into the record. It's a motion for an executive session next Monday, and I would ask Councillor Coop to basically say so move, and Councillor Paul to say second. Trying to make this as easy as possible.
Yes, we need a motion to hold a special meeting on December 2nd, 2013 at 5:30 p.m. in the City Manager's Conference Room. The purpose of this special meeting is to hold an executive session for the purpose of determining positions relative to issues subject to negotiation, receive reports on the progress and status of negotiations, develop strategy and instruct negotiators pursuant to Section 2.15 paren C paren 2 of the Lakewood City Charter and Section 24-6-402 paren 4 paren E of the Colorado Revised Statutes, and to consider the sale or purchase of property by the city pursuant to Section 2.15 paren C paren 3 of the Lakewood City Charter and Section 24-6-402 paren 4 paren A of the Colorado Revised Statutes, and specifically to receive a report on the status of negotiations and consider the possible purchase of real property in connection with a major development project in the city of Lakewood.
So moved.
Aren't you glad I did it that way?
Okay.
You have to repeat that.
Okay. You want me to?
All right. We have a motion and a second for an executive session. So Monday, December 2nd, we'll be busy. An executive session at 5:30, followed by a study session that has just been broadened in its scope. So get your rest on Sunday night. Anyway, motion and a second. Any discussion? Please cast your votes. And it passes unanimously. And I think that we no longer have to pass around those pieces of paper. So you won't be seeing. Normally, when we have an executive session, we don't have an opportunity like this to talk about it and approve it at a council meeting. And we have to have 3 or 4.
The mayor
plus 3 council members sign it. But anyway, we won't be seeing that this time. All right, on to the executive report. Ms. Hodson.
Yes, thank you. I was hoping to report this with a full packed chamber behind me. So can we get those folks back? I'm kidding. I wanted to announce that Margie Greer, our own city clerk, was recently awarded an Outstanding Contribution to a Municipality Award by the Colorado Municipal Clerks Association. This is a very honorable award for her, and we're so proud that she's our city clerk. And what this award represents is leadership and commitment to the profession. So a huge congratulations to our city clerk, Margie Greer.
Hooray! Congratulations, well deserved. It's late. I don't have any report. Happy Thanksgiving, everyone. Gosh, let's just go down the line here.
Happy Thanksgiving.
Happy Thanksgiving. Ramey, anything?
Just real quick, I'd like to say in Ward 1, we welcomed a new Carrabba's, which is awesome.
Yep.
Also a Bonefish Grill, and because I'm Polish, on Carr Street there is a Chicago deli that is to die for.
Really? Talk to me about that. All right.
Happy Thanksgiving.
Shakti?
Just that I'll be having 2 ward meetings a month, and one of them will be the first Monday of the month, and that will be at Sunrise Sunset at 8 a.m. The other one will be the 4th Saturday with Pete Roybal, and that won't be till January.
Great. Thank you. Tom?
Great. In Ward 5, we'll resume our ward meetings in December. December 20th will be the next one with Karen Harrison. Welcome to Karen and Shakti. And just one other brief thing. I was behind an RTD bus tonight. And I don't know that RTD has ever done this in the past, but on the back of it was a quote from John Lennon. It said, "Give peace a chance." And it had the RTD symbol on it. Just what a wonderful thing for them to do.
Nice.
Thank you.
Councilor Wickman. Karen? Margie? All right, we're adjourned at 9:59. Thank you.